It's perhaps best dealt with in several pieces. So upon filing the bankruptcy, it does depend on which chapter we're talking about as to ultimately what happens. But the big picture goal is to deal with debt, whether it's to simply erase debt in full in a Chapter 7, or to make provision to pay some or all of the debt over a number of years in either a Chapter 11 or a Chapter 13. So immediately after filing the petition, the court will forward a copy of that petition to the trustee if there's a trustee. In Chapter 11s, there typically is not a trustee. But certainly in Chapters 7 and 13, there's a trustee. So now let's go down the Chapter 7 path for just a bit. In Chapter 7, the Chapter 7 trustee will review the petition and the related documents for several reasons. Number one, the trustee is interested in grabbing assets. Now, the trustee can only grab assets that are non-exempt. What that means is when we list the assets in the bankruptcy petition, we divide them into exempt and non-exempt categories. The exempt stuff belongs to the debtors. The non-exempt stuff is in the bankruptcy estate, and it's fair game for the Chapter 7 trustee to seize and liquidate to have money to pay creditors. So that's the first thing that Chapter 7 trustee is going to look for. Are there any non-exempt assets? And Congress has given the trustee a real pecuniary incentive here, because any assets that are liquidated and proceeds distributed to creditors, the trustee gets paid out of that pot on a sliding scale that's described in Section 326 of the Bankruptcy Code. Now, a second thing that Chapter 7 trustee is going to look for is, were there any unauthorized transfers of assets prior to filing the bankruptcy? And they fit into two categories. There are what are called preferential transfers, where the debtors have transferred money or assets to creditors in anticipation of bankruptcy. And then are what are called fraudulent transfers, where the debtors have transferred assets perhaps without getting a reasonably equivalent value in exchange for the transfer, or to hinder, delay, or defraud the creditors. Because in those circumstances, depending on the chronology, the trustee can undo those transfers and seize the assets for the benefit of the bankruptcy estate. The term we use, by the way, is avoid the transfers. It's a somewhat unusual usage of the word avoid. It means to render null and void. And those are what are particularly interesting to the Chapter 7 trustee. And something on the order of a month, plus or minus a few days after we file the petition, we attend a hearing with that Chapter 7 trustee. The hearing is called the Meeting of Creditors, and in spite of the title, creditors rarely show up. At that hearing, the trustee is going to poke around to see, are there any things that can be seized for the benefit of the bankruptcy estate? If it looks like there aren't any such things, the case is referred to as a no asset case. The trustee will file a final no asset report, and that pretty much does it for the Chapter 7 trustee. Now, there are a couple of clocks that start to tick after that meeting of creditors. The first is the debt clock. The second is the asset clock. Now, why did a person file for Chapter 7 protection? To get rid of debts. Some debts, they just go away as a matter of course. Most credit card debt, medical debt. I mean, if you had a medical debt and you didn't pay, were they going to repossess your heart? No, they might take a kidney, but generally speaking, they're not going to come after body parts. Now, some debts you simply can't get rid of. End of discussion. Generally, student loans, except in a very rare circumstance, most tax debts, obligations to pay child support or alimony. There are some others, but there are three kinds of debts that will be discharged at the completion of the case unless the creditor in question successfully challenges the discharge of the debt. They are debts incurred through fraud, breach of a fiduciary duty, and willful and malicious harm to a person or property. The creditor doesn't have an open-ended time window to initiate such a challenge, which is done via a lawsuit called an adversary proceeding. The creditor has up to 60 days after that meeting of creditors takes place to file the complaint to initiate the lawsuit, with the understanding that if day 60 lands on a weekend or a holiday, it does spill over to the next business day. If the creditor hasn't done so by that 60-day bar date, the debt will be discharged. End of discussion. Now, I said there's also an asset clock here. What's going on there? Well, earlier I said that the debtor's assets are divided into exempt and non-exempt categories, and the debtor keeps the exempt stuff, the trustee seizes the non-exempt stuff. How do we exempt? We use an appropriate exemption table. But it is conceivable that someone could misuse one of the exemptions. I've got this nice Rolls Royce. I exempted it with a $5,850 car exemption. Well, somebody could say, I don't think so. And in that situation, the entity, whether it's the trustee or perhaps a creditor, can initiate a challenge to that exemption. That challenge must be filed no later than 30 days after the conclusion of the meeting of creditors. Now, you notice when I talked about the debt clock, I didn't say after the conclusion of the meeting of creditors. Sometimes at the meeting of creditors, a trustee will say, you know, I need some additional information. I'm going to continue the hearing for a bit. In that situation, that hearing has not been concluded. Now, the 60-day clock will start to tick at the end of that very first session, but the 30-day clock doesn't start to tick until the time that the trustee concludes the hearing. And then up until the end of that 30-day clock, anyone who wants to can initiate a challenge to an exemption. Same drill. If that lands on a weekend or a holiday, it does spill over to the next business day. If you get past the 60-day bar date, then you know your debts are going to be discharged, except for those debts that are by nature non-dischargeable. And then, well, it depends on how busy the court is. Typically, maybe about a month after the 60-day bar date has passed, the court will enter the discharge, and then something on the order of a week to 10 days after that, the court will close the case. So that's the typical pattern in a Chapter 7, and that does apply to married couples, but it also applies to individuals as well. Now, it doesn't apply to businesses. Although a business can file a Chapter 7, it can't get a discharge because the Bankruptcy Code grants a Chapter 7 discharge only to individuals, not to businesses. And that Chapter 7 bankruptcy for a business is generally liquidation, where all of the assets are liquidated and the proceeds are used to pay creditors. So those are kind of the key things here when a married couple files for bankruptcy in California, and as a matter of fact, it's pretty much the same coast to coast. Oh, I should pick up on something. I have a little bit of a lacuna here. I focused on Chapter 7. In Chapter 13, things are a bit different. In Chapter 13, rather than simply erasing debts in one fell swoop, the debtor, or in this case, the couple, enter into a multi-year debt repayment plan that's administered by the bankruptcy court. That plan has to satisfy a few requirements, and if you can propose a plan that satisfies those requirements, the judge will confirm the plan, and each month for the life of the plan, you make a payment to a Chapter 13 trustee appointed to the case who takes the payment, distributes it to the creditors according to the terms of the judge-confirmed plan. In the meantime, you don't deal with the creditors at all unless you have secured debts such as a home mortgage or a car loan where you continue to make those payments directly to the creditor. This is in contradistinction to what happens in other parts of the country. But here in the Central District of California, we don't have what are called conduit payments. Instead, you keep making those secured debt payments directly to the creditor. But the unsecured creditors, they get paid through the plan. Now, there are several requirements of the plan. I wanted to focus on one because it's intimately connected to what we just talked about in Chapter 7. It's sometimes referred to as the best interests of creditors test, or requirement, if you will. It's also known as the Chapter 7 liquidation requirement for Chapter 13. What it says is, over the life of the Chapter 13 plan, which can last up to 60 months, it can't last more than 60 months, you have to pay back your general unsecured creditors at least as much as they would have gotten in a Chapter 7. Now, in the Chapter 7, you lose non-exempt assets, which are liquidated by the Chapter 7 trustee for the benefit of creditors. So in that situation, if there are non-exempt assets, the creditors would get paid something. That's the starting point for the Chapter 13. Over the life of the plan, you have to pay the general unsecureds at least that liquidation value of the non-exempt assets. Now, in exchange, you get to keep the assets. No trustee is going to seize any assets in a Chapter 13. So that's a fundamental difference between Chapter 7 and 13. Now, there are lots of other requirements. Some are make or break requirements. Some are, well, you need to get this done, but your case isn't going to be dismissed immediately if you don't. But that, in a very brief nutshell, is what happens when anyone, including a married couple, files for bankruptcy in California. I would talk about Chapter 11, but that's a much more complicated chapter, and perhaps we should relegate that to another discussion.